Let's start with the application of the Article 60 and cooperation of DPC with other supervisory authorities, with the board when making these high-scale decisions. And maybe you can share some experience about the lessons learned in this exercise during the last and most controversial case with the Meta platform Ireland, which was fined on with the published decision on the 22nd of May. So what are the lessons and what is your experience in that case?
Yes, so I'll just say myself, my responsibility as the Deputy Commissioner here in the DPC, I'm responsible for the whole area that deals with cross-border complaints from the public, among other things, and prosecutions and so on. So I haven't been at the process that you're talking about, the Article 60 or the 65 process, but I certainly am involved in the Article 60 process, because in fact, even our most basic complaints that are not amicably resolved do go through the Article 60 process. And I suppose the one key thing that all of these have shown over the last 5 years in terms of the Article 60 and the Article 60 process, these weren't built for speed. That sums it up. You know, it's a very slow process because you are required to engage with your supervisory authorities in the other member states, and it happens all the time. Obviously, the DPC cases, because they're dealing with very big tech investigations, many of them, it has got a lot of publicity because many of them have gone to the Article 65 process, and that's there's time frames set within that. But every day across the other supervisory authorities in the European Union, there are draft decisions being circulated to us all, you know, and very few of them go to Article 65 because I suppose the supervisory authorities do actually change tack. So it's not unusual and it's part of the process that we all engage, we all help one another in terms of evaluating a draft decision. So, for example, I'm looking at one over the last 2 weeks. I'm not going to name the particular supervisory authority, but it is a supervisory authority, one of the main ones in mainland Europe. They did a draft decision, for example, back in September of 2019, and they agreed with the data controller about contract basis being the legal basis for a particular thing. They actually agreed. But one of the other supervisory authorities, when they saw the draft decision, objected and said, no, we have a relevant reason of objection. That can't be possible. So what has happened in the meantime is that the first supervisory authority has gone back and has revised, has now come up in May of 23 with a revised decision. And the deadline for that is this month. So this is happening all the time in terms of at draft decision stage, changes are made. And it doesn't get as much publicity, by the way, as what happens with the Article 65 process, but it's the same thing in terms of engagement and with the other supervisory authorities having their say. And it would be naive to think that there wouldn't be differences of opinion in terms of there being 47 supervisory authorities across the European Union and the EEA area. Of course, there's going to be differences of opinion. And there's no way a draft decision in the norm, particularly got to do with a big tech inquiry where there's massive amount of documentation in those decisions. If you see any of our decisions, if you take the one now this week, that ran to over 200 pages. And it's full of legal analysis. So unquestionably, when we send something to Article 60 as an Article 60 decision as comprehensive as that, it's going to attract different opinions. By the way, even the most basic one, just to say from our perspective, I am the decision maker for many of the cases that result from one person's complaint about one issue. And it may simply be about they've been banned and they have a data protection issue with a particular platform that has banned them. I'm the decision maker on those cases. And even in those decisions, and you will see some of them published on our website, an example I would give, there was one I did on Twitter, there was another one on WhatsApp and so on. And they're not the ones I'm talking about, the big tech ones, but they happen to relate to some of those big platforms. Even my own decisions that I do run to about 20 pages because we have to go through a very comprehensive analysis, etc., in terms of standing up in the court appeal afterwards. So what I'm saying to you is that the GDPR was specifically designed for everybody else to have a say, and that does assist. So in the case of Meta case this week, that obviously did assist as well. We would not have been going down the road of ourselves at the DPC of implementing a fine as one of the corrective powers. Some of the other authorities thought differently. So there was 47 concerned supervisory authorities consulted on that. It was 4 of the supervisory authorities who had any objections. So that means that 43 were in agreement with us, 4 had some objections, and one of the objections eventually was about applying the administrative fine. And then we are once the EDPB made its binding decision, we're bound by that. So it's the final decision then that we issued this week is the DPC's decision, having taken on board. So it's all a very complex process. It's hard work, but we did start off 5 years ago today from a greenfield site. Nobody knew how this thing was going to work or what was going to be involved. We're learning as we go along, obviously, and we are cooperating with the other supervisory authorities. As I say, equally, the ones that people talk about and hear about in the media are the Irish cases, because we have so many big cases on our books. We've about a dozen, I think, gone through very significant ones, you know. So yeah, it can be challenging, interesting, but at the same time, at the end of the day, what's really good and what's coming out of the decisions is not necessarily the big fines which grab the headlines, like this week the fines, etc., is what's talked about, and even in our own case, since over the last 5 years, we have imposed fines of over 2.5 billion euro. What's more significant, I think, is the corrective powers, because that's what has the real effect. You know, some of the companies pay up the money or don't pay up the money, or if they go to challenge it in court. But it's not about the money, really. It's really about the corrective powers. And in most cases to date, thankfully, even while there are appeals going on, some of the companies that have appealed some of the decisions have, without prejudice to the appeals, they've gone ahead to implement some of the corrective powers that we've imposed upon them. So we are entitled to, in some of those decisions, in any of them that we feel is necessary, to require a company to change its processes, to bring their processing into compliance, and that is going on, and that's very positive, because it's having effect. But the other important thing for your audience is, in terms of those decisions, is the precedential value it sets, and it gives other data controllers a very valuable insight into what regulators are thinking about particular topics. For example, there was a very significant case relating to WhatsApp, which related to the concept of transparency. That's for every other data controller to read and be aware of and to take cognizance of. Even on the very first decision that we ever did in terms of one of the big tech companies related to Twitter, and it was about late reporting of a breach. And again, the thinking then of the regulator in relation to the application of that particular part of the GDPR. All of those are very useful. We've come a long way, like in the 5 years that there is now, in a sense, case law, for want of a better word, that data controllers can tune into and apply, obviously, in their own areas, you know.
Tony, if I may, coming back to this Meta decision, right? And for me, at least, it's very curious. I mean, you were bound, right, by the board decision as far as the administrative sanction is concerned, because, well, just to get the perspective, the DPC hasn't proposed, right, the fine in the first place. And it was actually after this procedure when this 1.2 billion has come up. But it's interesting, if Meta appeals the administrative fine in the Irish courts, and the DPC would be defending the fine, which it hasn't even proposed in the first place, don't you think that it would be quite an interesting position in the court?
Yes, well, obviously we haven't received appeal papers yet, so there's very little I can say on it, other than in other cases, I'll put it that way, in other cases that have been appealed, and where, again, the binding decision of the EDPB has made us change or supplement some of the findings. We have, and we are defending those decisions. So in the particular case of this week, until we receive, we have heard in the media, reported here in Ireland, the media did contact the data controller, and it was reported by the media that there will be appeals, but not only an appeal of the decision, but also they will, according to the media, apply for a stay on the orders. Now, as I said a few minutes ago, that hasn't happened before on any of the other cases. So if there was a stay put on the order, well, then the order cannot proceed while the stay is there. But to go back to your point, then, without knowing the content of the appeal, because it hasn't been lodged yet, I'm only going by previous other cases, and we certainly would. It is, at the end of the day, the final decision that issued in any of those cases in the past is the final decision of the Data Protection Commission in Ireland. And it's that document that's been appealed. So until we see the papers for any forthcoming appeal on Monday's process, we don't know what they will be appealing. But going by previous cases, we would be defending, and we have defended the other cases, absolutely.
Okay, and Tony, just shedding some light on the 5 years of GDPR, experience in Ireland and in your DPC activities. What are the key topics you were investigating apart from the data transfers? What are maybe key topics or key areas?
Yes. Happy to talk a little bit about that. Obviously, I mentioned there the WhatsApp transparency. There are such significance in all of those big tech inquiries. As I said, there's about a dozen of them. But the transfers case stands out, given how long it was going on, etc., and all the particular legal proceedings that took place. It stands out as a very, very significant one. As I said, the transparency one as well. The one, in fact, the Meta breaches was very interesting as well, where there was 12 breaches and they were fined 17 million euro. They reported data breach notifications to us over a period of 6 months, and we circulated that particular one as well. And in fact, in that case, which is interesting to talk about the process of Article 60. In that case, again, when we sent through the first draft decision, there were a number of objections from, I think it was 2 supervisory authorities, but we were able to actually resolve those through talking to the supervisory authorities concerned. But what was interesting as well about that one is there was a fine of 17 million euro imposed on Meta in relation to that one, and they did not appeal it. And then we have to go to a process again in court here in Ireland to get the fine confirmed, and that fine was confirmed, and Meta have paid over the 17 million. That's the only fine that has been paid to date, by the way. Another one that's of interest to me in terms of key things that we've investigated over the years is again, it's nothing to do with the big tech, which gets all the publicity at a European level. I'm very interested in more matters close to home, and particularly in relation to state surveillance. And we have a huge inquiry going on here in Ireland at the moment in relation to state surveillance by the government and our government local authorities here in Ireland and the police. And we've had some significant decisions which are published on our website in relation to that. And what I'm talking about particularly is the use of CCTV cameras by local authorities, government agencies, and by the police. And particularly, and we've one published where we, unfortunately, most of it doesn't fall under GDPR. It falls under the Law Enforcement Directive, which came in also in May 2018. But for those aspects that fell under the GDPR, there was one local authority in the west of Ireland which was fined 110,000 euro last year. But it's not really, as I say, about the fine that interests me. It's about the corrective measures and what happened as a result. And I've been down there in doing physical inspections of this. They had to remove from their cameras all ANPR capability, which is automated number plate recognition, which was a big thing. You know, they had invested in this technology, but it was disproportionate for what they were doing. And another thing they've had to remove at local authority level was traffic management cameras. No legal basis in Ireland for it at the time. Also, local authorities had cameras over for detecting litter, and they had where you'd have a bring back for litter bottles. There was no legal basis for that. We've had all of those switched off. So the impact on that is far more significant from the ordinary citizen going around, because they cannot avoid those cameras if they're going to the litter bin, or if they're passing a place where there was a traffic management camera. These are huge, and these are issues that more and more regulators should be looking at in Europe, as well as, for example, a big huge thing that I did as well at one point was the hospital sector and the medical records. We've gone through a quarter of all the hospitals here in Ireland looking at their processes in terms of the management of a file from the time you arrive at the accident and emergency department to the point where you're discharged, which may not be for weeks or days, or it could be the same day. But we followed the trail of the file, and it was quite shocking, in fact. So we published a report about this, which many data controllers look at, because the same principles apply in every data controllership in the country, and across the European Union. And these are, while the big tech inquiries get all the publicity because there's big fines and so on, there's far more, indeed, significant work often that affects an individual who's dealing with the state. Most people, when they're dealing with the state, they don't have a choice. The state takes data for various things. You're applying for planning permission, or you're applying for a grant or whatever, and you don't have a choice but to give the data. You do have a choice whether you're on Facebook or on Twitter, but most people don't have a choice. And people who are handling that data then in the state agencies, they're in a very privileged position. And I uncovered huge abuse in terms of private investigators in Ireland operating, particularly for insurance companies and for financial institutions, leaning on officials, paying money for data that was held by government bodies, blagging, fooling officials, ringing up, pretending there was somebody else, but equally able to get easily through. So here in Ireland, as a result of some of the activity that I took on in the last few years, at least half a dozen staff have lost their jobs. They've been dismissed. A number of members of the police have even lost their jobs. There's even a case last week was brought up. It's now started in the court under the new register, under the 2018 Act here in Ireland. I was reading last Saturday that a member of the police here in Ireland has been brought into court last Friday, charged with breaches of the Data Protection Act for accessing the Garda system and giving information to people. So it's amazing what is happening out there, and particularly if you have a business audience today, they would want to be very careful and cautious about hiring private investigators to track down people, because here in Ireland, all of those need to be licensed now. Since the work that we did in the Data Protection Commission, licensing has come in, etc. Those are the things that really affect people, that people are snooping on them. And particularly if people lodge a claim against an insurance company, etc., they're likely to be followed. If it's a significant claim for an injury, the insurance companies here in Ireland are likely to be hiring a private investigator to follow them with a camera, etc., etc. That's just to highlight some of the significant issues that's going on that are affecting data subjects, and which data subjects come to us about in great numbers if they're aware of it. The other big issue, of course, is access requests, and access requests there, which is a hot topic because it is the biggest topic in terms of complaints to the Data Protection Commission, and data controllers need to up their game really in terms of dealing with that. So hopefully that answers your question on some of the issues
Tony,
we've been
absolutely.
looking at over the last 5 years.
Yes, thanks, Tony. Really, thanks, Tony. That answers a lot. And basically, we have many more. However, we are behind the schedule. So I once again thank you for being with us. We had Tony Delaney from Data Protection Commission in Ireland. Thank you, Tony, once again for being with us.